I extend a very warm welcome to all those who are present this afternoon. Uh, we have the pleasure of having with us today Professor Madhu Kishwar, who is a senior fellow currently at Nehru Memorial Museum and Library. She is an eminent scholar, editor, and many other things, as we all know. Till 2016, she was professor at the Center for the Study of Developing Societies and director Indic Studies Project at CSDS. In 2016, she was awarded National Fellowship of the Indian Council for Social Science Research. Her latest book, Beyond Copycat Feminism, Women's Issues from an Indic Perspective, is...
Latest book is The Girl from Kathua, sacrificial victim of Ghazwa Hind.
All right. And in 2014, she wrote another important book, Modi, Muslims and Media, Voices from Narendra Modi's Gujarat, published by Manushi Publications. The topic of her lecture is the tortured history of Uniform Civil Code from 1950s to 2023 and a simple strategy to break the stalemate. As we are all aware, Uniform Civil Code is one of the most debated questions in our society and polity. We know very well that as a nation, India has a lot of social, cultural, religious, economic diversity. When the Constitution was framed, there was a section called the Directive Principles of State Policy, where those provisions were kept which were supposed to be not justiciable like the fundamental rights, but which were supposed to define the basic philosophy of the republic which was being initiated, and they were supposed to guide, as it is said in the Constitution, the state's policy in all those matters. And in the Constitution, the Article 44, within this category of directive principles of state policy, says clearly that, I don't remember the exact language now, that it shall be the duty of the state to try to implement a uniform civil code for all groups and communities in India. And I believe that Professor Madhu Kishwar will touch upon how in the 1950s, when the question of reform in the personal laws of various communities came up, Pandit Jawaharlal Nehru took the questionable stand that these things, these reforms at that time were needed only with regard to the majority community, and perhaps for other communities and groups, reforms in marriage, succession laws, maintenance, inheritance, which are the things governed by the civil code. And as we all know, the criminal code, of course, is the same for everybody anyway. So that regarding these things, a decision regarding a decision on other communities can be taken later. And the question then, of course, remained pending till in 1986, Shah Banu judgment came, and a section of ultra-orthodox Muslims, Muslim clergies argued that this was a violation of the Muslim personal law, and the Supreme Court had no right to interfere in the personal laws of the Muslims. And we all know that, a lot of things happened since then, and ever since Uniform Civil Code and related things like triple talaq, etc., they have been at the center of debate in India. So without further delay now, I would like to extend a very warm welcome to Professor Madhu Kishwar and request her to proceed with her lecture.
थैंक यू जी। और मैं आपसे क्षमा मांगती हूँ, 5-7 मिनट लेट हो गई। ये ऊबर की मर्ज़ी थी, मुझे कहा तो गया था 20 मिनट पहले पहुँचा देगी, पर फिर घुमाती रही। खैर चलिए, तो लेट्स गेट गोइंग straight. This paper is a small part of my larger study on the Hindu Code Bill, which was first introduced in Parliament in 1948. At that time itself, strong voices were raised in Parliament from within the Congress party against Nehru's aggressive and selective targeting of Hindu Samaj for ill-conceived reforms against their wishes, while willfully evading the enactment of a uniform civil code as promised in the directive principles of the Indian Constitution. And those of you interested in my critique of the Hindu Code Bill, there's a long paper I published way back in, I think, 1980s or 1990s in the Economic and Political Weekly. But now I am revising it further and perhaps bringing out an enlarged manuscript in the form of a book on Hindu Code Bill all over again. But right now I'll focus on this controversy with regard to the Uniform Civil Code. Since BJP is the only political party that has made a long-standing commitment in its manifestos to introduce a uniform civil code when in power, all those parties that are desperate to bring down the BJP-led government at the center have found a convenient tool to mobilize anti-BJP hysteria among Muslims and Christians using the fear of Hinduization through UCC. This is happening despite the fact that Article 44 of the Directive Principles of the Indian Constitution clearly mandates that the state shall endeavor to secure for all citizens a uniform civil code throughout the territory of India. Yet anyone raising this issue today is promptly dubbed as anti-minority, communalist, a Hindutva-vadi fascist wanting to impose majoritarian norms on religious minorities. This viciousness in dealing with Hindu concerns started from day one of Nehru's reign. Anyone who opposed his arbitrary acts, policies, and the newfangled laws he rammed down the throat of Indian society in general, and Hindu society in particular, was demonized and vilified as communal, right-winger, holding obscurantist, unprogressive values. Using this typically leftist technique, Nehru let loose a vilification campaign even against the tallest leaders of the Congress party, such as Sardar Patel, Dr. Rajendra Prasad, Purushottam Das Tandon, Shyama Prasad Mukherjee, and a host of others, because they were not deracinated Hindus. Therefore, they did not whitewash the genocidal violence and brutal oppression suffered by Hindu Samaj during the Islamic invasions, followed by the establishment of Islamic rule in India. So this really was the litmus test, whether you were considered progressive or not. To be considered progressive, you had to whitewash all that happened during Islamic rule. The parliamentary debates on the Hindu Code Bill, which was later split into 4 different acts due to massive resistance within the Congress party, revealed the authoritarian and malicious streak of the Nehruvians with regard to Hindu Samaj, its culture, and dharmic values. In the 1950s, the Muslim leaders were somewhat on the defensive because they had voted for Pakistan and yet chose to remain in India. At that time, they would not have been able to resist the introduction of a uniform civil code, especially if it was handled astutely. By the way, I'm not a great votary of uniform civil code. I have serious reservations about it, but that we'll come to later. Today, leading Muslim outfits are preparing for many more partitions of India. Bharat tere tukde honge, inshallah, inshallah, is a serious war cry. So is their slogan, Bharat ki barbadi tak jang chalegi, jang chalegi. Some others have already declared their plans to complete their mission of bringing all of India under the rule of Islam and turn it from Dar al-Harb into Dar al-Islam by the year 2047 as part of Ghazwa Hind, which involves conversion of all non-Muslims to Islam and slaughter those who refuse conversion. Muslims living in Dar al-Harb are expected to look for excuses to launch wars against Kafirs, and the UCC issue provides an easy handle to the cry of Islam in danger and declare war on the kafir-run state of India. Therefore, under the present conditions, the imposition of the Uniform Civil Code is likely to lead to widespread bloodshed to match the slaughters of 1947. Considering that the Modi government buckled under the pressure of Islamists and withdrew an inconsequential legislation like the CAA, one can imagine the heat Modi government will face if he attempts to impose UCC on Muslims against their wishes. It may well lead to a civil war-like situation for which the Muslim leaders are prepared, but certainly not the government of India or Hindu society. From the very first day of the introduction of the Hindu Code Bill in 1948, leading voices within the Congress party, including the then President of India, Dr. Rajendra Prasad, raised serious and perfectly valid objections to it. Nehru was repeatedly reminded that the directive principles of the Constitution, which as the Prime Minister of India he was duty bound to uphold, assure the citizens that the state shall endeavor to enact a uniform civil code. Why then was the government brazenly violating the directive principle regarding UCC by selectively targeting Hindus for reforms against their wishes? And that's very important. Nehru was repeatedly asked to explain why were Christians and Muslims being spared the benefits of reform if the proposed reform were indeed so good for society. Why were Muslims and Christians given super special exemption with regard to their religious laws while Hindu Samaj was being bulldozed into accepting ill-informed and ill-conceived assaults on their age-old practices? And I'm saying it now, not now. As I said, you can read my paper in the in EPW, published in 1990s, but I wrote it way back in 1980s, which tells you how ill-informed and ill-conceived those laws were. Parliamentarians also reminded Nehru that the Hindu society had never demanded reform of their customary laws from the Congress party. The Hindu Code Bill was not part of the election manifesto of the Congress party, and that's very important. That if you've just fought an election and there was no mention that this is what you're going to do, why then was Nehru so desperate to reform Hindus without their consent and agreement? Even the British rulers used to carry out widespread consultations with the concerned communities before introducing any social legislation. But Nehru rammed down arbitrary and ill-conceived reforms that were aimed at tearing asunder the social fabric of Hindu society, including its diverse family structures. And in fact, I've argued in that paper that the Hindu Code Bill, or the 4 acts, Hindu Marriage Act, Hindu Succession Act, etc., took away more than they gave to women. But the rhetoric of equality was very seductive indeed. Nehruvians were rightly accused of being ill-informed and prejudicial against the culture and diverse practices of Hindu society prevalent at the ground, in addition to having zero knowledge or respect for Hindu Dharma and its Shastras. As is typical with leftists and Islamists, the two forces that held Nehru tight in their grip, Nehruvians never bothered to respond to these valid critics. Kabhi jawab nahi diya. Ye abhi bhi yahi chal raha hai. Instead, they used offense as the best form of defense by disdainfully labeling all critics as communal, divisive, and anti-minority. The same game of defamation and slander is being played out even today on the issue of UCC with greater ferocity. The following extracts from the Lok Sabha debates provide a glimpse of the kind of objections that were raised with regard to Hindu Code Bill and the disdain with which they were dismissed. Congress MP, I quote, I've just given you small quotes, but the debates, the parliamentary debates are full of these objections every time one of these laws came up for debate in the parliament. Mr. Deshpande says, when I try to understand the meaning of the Hindu Code Bill, has it anything to do with the name Hindu? Does it signify that it is based on Hindu traditions, Hindu ideas, personal law and values, and the great culture which the Hindu society or the Hindu nation has created during the last so many millennia? The government is going to introduce certain mischievous principles which it dares not apply to the Muslims, Christians, Parsis, or Jews. Hindus are the only community to whom the bill is restricted. The law minister has not cared to inform us or acquaint the House how all the provisions given in the bill are based upon Hindu customs, Hindu legal traditions, etc. Hindu Code Bill is a big conspiracy to encroach upon the personal laws of the Hindus, and they are trying to defend the Hindus to whom this bill will apply. I know this is going to be repeated in every installment. When we come to oppose it, we are called communalists and reactionaries, and those who support it are the secularists, non-communalists, and nationalistic legislators. They are enacting law after law restricted to particular communities. When Acharya Kripalani asked the law minister, and mind you, Acharya Kripalani was not a Hindu Sabhaite, he was also Congress. I wanted to know, whom does the law minister represent? Does he represent Hindus or does he represent the people of India? He got the following imperious answer from Pataskar, testifying to Pataskar having adopted colonial lenses for viewing Hindu society. He says, I quote Pataskar, I represent the people of India. I do not claim to represent here the Hindus. On the contrary, I was trying to make out that there was nothing like a Hindu 200 years ago in this land. भाई हिंदू थे ही नहीं आप, तो इसलिए हिंदू हिंदू क्यों चिल्ला रहे हो? 200 साल पहले तक कभी अंग्रेजों ने आपको हिंदू बनाया. It is only when the British administration was introduced that this term came in. Therefore, I say that I am proud that I represent the Indians, and what I am trying to do here is in the interest of Indians. At this, Sri Loknath Mishra quipped, why then pilot this Hindu marriage bill? If you are representing Indians, तो भी Indian marriage bill करो ना, वो तो था ही. And Sri V.G. Deshpande added, then why not an Indian marriage bill? The following response by Pataskar is a typical case of ulta chor kotwal ko dante, a technique borrowed from commies and mastered by Nehruvians. He says, I would request the learned members to have patience. Even that point will be answered. I am also aware that they raise these objections not from the point of view of doing something for the Indians, but they are trying to persist in the separation of Hindus and Muslims from others, which was the result of foreign administration. I mean, does it even make sense? आप ला रहे हो केवल हिंदुओं के लिए बिल और आप कह रहे हो कि जो अपोज कर रहे हैं कि आप सबके लिए लाइए ना, तो वो डिवाइसिव है और आप जैसे समाज को इकट्ठा जोड़ के रखना चाहते हैं. It is the Nehru government that was pursuing a divisive agenda, but it accused those who opposed this ill-advised move for bringing in a blatantly communal legislation. I quote another MP, Mr. N.C. Chatterjee, who exposed Nehruvian hypocrisy and doublespeak without mincing words. To quote him, daily the Congress leaders are harping on the evils of communalism. The Prime Minister of India is ranting on the menace of communalism. What business has this Congress government to bring up a communal legislation, a communal code of this character, directly infringing the directive principles of the Constitution? I do maintain that this kind of communal legislation, which is marriage law for one community or divorce law for one community or fixation of a particular age for marriage for Hindu boys as distinguished from Muslim boys, a particular age of minority for one community and not for another, is an infringement of Article 14 of the Indian Constitution, also Article 15 of the Constitution. This is completely out of tune with the concept of secular democracy, which Sri Jawaharlal Nehru is daily preaching throughout India. If you think that something is good for one particular community, it must be good for all. And you should plan it out, plan it on that basis, and you should not say that simply because some people, some so-called progressive people, some so-called fashionable people are wedded to the Hindu code, that you must legislate for codification or reformation of only one law for one community. So the woke lobby in Congress, I mean, the word is new, but obviously the Congress was taken over by wokes of the Nehruvian vintage right at the start. And he says this is not consistent with fundamental rights which you have given in the Constitution. Are you not really defying the guaranteed freedom of equality? Okay. Then he went on to add, Sri R.K. Chaudhary also pointed out rather strongly, Do the masses, do the women of the country really want this legislation? If the progressive section of the ladies want it, are their desires not satisfied by the provisions of the Special Marriage Act, which is already in force? Even though the marriage might have taken place under Sanatan Dharma, they can register their names under the Special Marriage Act, and with consent, they can effect divorce quickly. Why then do you want to outrage the feelings of Hindus by giving this bill the name Hindu Marriage Bill? And actually, it was so gross, the entire debate and the manner in which the Nehru government crushed all dissent and never bothered to really answer the questions that were being raised. This bill is as good as the Special Marriage Act, which can satisfy the aspirations of the educated women of this country, because it's a small section of articulate Western educated women were mesmerized by Nehru and they were supporting it. But by and large in the country, there was strong opposition to it. And he says, you are ashamed to be Hindu. You do not like many things of Hindus, but still, why do you want to glorify yourselves by saying that you are having this Hindu marriage bill? So, that it is un-Hindu, it is anti-Hindu, it is not even based on facts on the ground, that you don't know the Shastric laws either, nor do you know what is actually prevalent on the ground, because Hindus are not always governed by Shastric injunctions. Customary law is forever evolving in a very creative way among Hindus, and I've documented all that in my paper that you can read in the EPW. Now, what is most interesting and ironical is that Nehru nullified existing common laws as part of divide and rule game. A devious justification offered by Nehruvians for bulldozing Hindu society into erasing its diverse practices out of existence and accepting uniformity of law was that this would pave the way for a uniform civil code for all communities, and that passing the law for Hindus would strengthen the hands of the government to pass it for other communities too, which was actually a lie. Nehru never intended to do that. However, in actual fact, the passing of a supposedly secular law for Hindus, but giving it the name Hindu, it's secular, but he insisted on calling it Hindu, which in fact is greatly influenced by British Christian law. It had the opposite effect of a movement further away from uniform civil law. When the Nehru government codified Hindu laws in this arbitrary manner, it actually undermined earlier laws enacted by the British, which had been applicable to all communities. And these civil laws had been accepted without protests by Hindu, Muslims, Christians alike. The case in point is the Hindu Minority and Guardianship Act of the Hindu Minority and Guardianship Act of 1956, pushed down the throat of Hindu society by Nehru government, was a classic example of introducing a divisive legislation while undermining the already existing Guardians and Wards Act of 1890. This 1890 Act, passed by the British, applied to guardians and wards of all communities, Hindu, Muslims, Christians alike, and yet the Hindu Minority and Guardianship Act of 1956 was passed in addition to the Guardians and Wards Act of 1890. This actually effectively put an end to adoption by Muslim families. They haven't still recovered from that onslaught. There was nothing particularly Hindu about the provisions of this new 1956 Minority and Guardianship Act. In fact, the provisions were conceived with an authoritarian colonial bias, giving government powers to interfere with parents in a way unknown to the Hindu or any other community. If any law was to pave the way for a uniform civil code, it would be something like the Guardians and Wards Act of 1890, and this was repeatedly pointed out in the parliament. As Pandit Thakurdas Bhargav argued, this is an absolutely unnecessary bill, and it also goes against the principles of having a common civil code. this is a mischievous bill insofar as the provisions of the Guardians and Wards Act will not apply uniformly to all nationals. Now, a Hindu minor will be quite different from a Muslim minor and a Christian minor. It creates more distinctions than are there in the present law. But none of these warnings were heeded. The result is for all to see. 7 decades later, we are today likely to face a real civil war-like situation if the government were to force a UCC on Muslim communities the way it has coerced Hindus to accept unwanted, undesirable reforms aimed at deracinating Hindu society. Now, and it has really disoriented Hindu society. They've lost their moorings, they've lost their roots in their culture, tradition, कुछ पता ही नहीं है और कोर्ट्स कैसे चलती हैं वो पता समझ ही नहीं किसी को आता. You become hostages to the caprices of lawyers, corrupt court procedures, and as you well know, how much harassment and wastefulness, how harassing, demeaning are court procedures. And this is another thing that was pointed out to the government repeatedly, कि आपकी कोर्ट्स नहीं हैंडल कर पाएंगी. सारी मैरिजेस जा रही हैं, डिवोर्स के लिए जा रहे हैं, गार्डियनशिप के लिए जा रहे हैं अदालतों में, तो आपकी अदालतों के पास क्या कैपेसिटी है ये सब हैंडल करने की जो समाज अच्छे से हैंडल कर रहा है? परंतु किसी ने नहीं सुनी. और आप खुद भी देखते हैं मिलियंस ऑफ केसेस आर पेंडिंग और तीसरी पीढ़ी में जाके कई बार जजमेंट मिलती है. लोग मर भी जाते हैं पिटिशन, जो ओरिजिनल पिटिशनर्स, और उनके दूसरी पीढ़ी या तीसरी पीढ़ी कभी शायद उनको न्याय मिले या ना मिले, जजमेंट मिल जाती है. खैर, नाउ द बिग क्वेश्चन इज, do only Muslims follow personal laws? In popular perception, the stalemate on the UCC is on account of the intransigent attitude of Islamists who insist that the Indian state has no business to tamper with their religious freedom by imposing man-made laws on them, because they think Quranic injunctions and Sharia are Allah's own commandments. Most people rooting for the enactment of UCC are under the mistaken impression that only Muslims and Christians follow their customary or religiously ordained laws. The reality is that even Hindus, by and large, follow the old customary practices, which are not religious in the same way that Islamic and Christian laws are, because our customary practices don't draw strength from one God-given book of commandments, and our customary law is open to changes, and it has been undergoing evolutionary changes throughout centuries, and all Shastras and Smritikars say that. The reality is that even Hindus by and large follow the old customary practices prevalent among their respective jatis. Not necessarily all Hindus have one kind of customary practice, but Hindus continue with many of the practices of their respective jatis, sects and communities, because the state enacted laws never took deep root. आज भी अगर आप पूछें किसी से हिंदू मैरिज एक्ट क्या कहता है, हिंदू डिवोर्स एक्ट क्या कहता है, सक्सेशन एक्ट, most people, even highly educated ones, come to look at those laws only when there is a conflict in the family. कोई डिवोर्स का पॉइंट आ गया, प्रॉपर्टी पे झगड़े हो गए, तब जाके देखते हैं भैया कानून कहता क्या है. किसी को कोई खबर नहीं होती. और मेरे पास तो, क्योंकि मैंने बहुत लीगल एड की है, पीएचडी वाली भी आती हैं महिलाएं या पुरुष भी अच्छे एजुकेटेड, जब परिवार टूटने की नौबत में होता है, टेढ़े मेढ़े केसेस एक दूसरे पे किए जाते हैं, तब कहते हैं पर हमें पता ही नहीं था ये कानून है, हमें पता ही नहीं था, कोई पढ़ता भी नहीं है और किसी ने कोशिश भी नहीं की समझाने की. खैर, फॉर इंस्टेंस, मोस्ट हिंदू ग्रुप्स कंटिन्यू टू अवॉइड intra-gotra marriages because they consider people belonging to the same gotra as sharing a brother-sister bond. Therefore, in the moral universe of Hindus, a sagotra marriage is as good as incest. An overwhelming majority of Hindus uphold this belief with passionate zeal, even though there is no bar on Sagotra marriages in the Hindu Marriage Act. I hope you know what is Gotra, I'm sure most of you would. Likewise, the custom of marrying within one's jati and biradri continues among Hindus, even though the Hindu Marriage Act does not require people to marry within their traditionally defined boundaries. Just as marriage among Hindus gains real sanctity only when recognized and celebrated by the concerned family and kinship group, so also among poorer sections of society, divorce or separation is often settled through biradri panchayats rather than through law courts, which are too distant and intimidating for those with meager incomes. अधिकतर लोग डाइवोर्स नहीं जाते हैं कोर्ट में करने, सेपरेशन बिरादरी के सामने पंचायत बैठी कर ली और 2 पैसे भी नहीं खर्च होते. Such divorces are considered valid by Samaj, even though the criteria used for community negotiated separations are very different from the provisions of the state enacted divorce law, which is adversarial. आपको प्रूव करना पड़ता है कि वो बहुत बेईमान है, वो झूठा है, वो फरेबी है, इसलिए मुझे इससे छुट्टी चाहिए. तो ऐसा कम्युनिटी मैनेज्ड separations में ऐसा नहीं ज़रूरत पड़ती. These are merely illustrative examples of the fact that Hindus did not slavishly surrender their customary practices if they found them more sensible and useful than government enacted laws. More interestingly, large sections of Hindu society have adopted new customs, including those that go against the law of the land. For instance, despite the enactment of a draconian anti-dowry law in 1980s, giving and taking of dowry has become more prevalent today than it was 100 years ago. In fact, the culture of dowry giving has spread even to communities that had no such tradition. And dowry giving, unfortunately, is justified as a customary practice as per the Dowry Prohibition Act, even though it is of 20th century vintage. 19वीं शताब्दी तक किसी ने नहीं पढ़ा होगा कि दहेज समस्या है, डाउरी बैन करो, ऐसा कुछ भी. ये 20th century में आते आते कुछ नए forces unleash हुए, जिससे dowry became an issue by mid-50s, and of course then Dowry Prohibition Act के बाद तो और भी ज़्यादा बढ़ गई ये समस्या. In fact, as per Hindu tradition, daughters' share in family property was given the sanctity of Stridhan, which was non-alienable and passed from mother to daughter. But Stridhan has been replaced by dowry among most communities, even though Stridhan is as different from dowry as is chalk from cheese. However, Hindus have been bulldozed into blindly and timidly accepting government-imposed reforms, including those that are forced upon Hindu society with malicious intent by forces hostile to Hindu dharma and are meant to tear asunder the social fabric of Hindu society. आपने देखा है पिछले 2-3-4 दशकों में तो ये फॉरेन फंडेड एनजीओ शुरू कर देते हैं कोई भी इशू को लेके, और फिर आनन फानन में शोर मचा के मीडिया, कैप्टिव मीडिया तो होता है, और सरकार का इतना दिमाग चाटते हैं, और मीडिया क्योंकि सपोर्ट करता है तो बहुत जल्दी कोई भी कानून पास करा देते हैं, और पार्लियामेंटेरियंस को भी अक्सर नहीं पता होता वो क्या कानून पास कर रहे हैं. The ease with which the Nehruvian minority in the Congress party launched lethal attacks on Hindu society in the name of women's empowerment through ill-informed and poorly conceived reform measures targeting Hindu customary laws in 1950s was just the start of this process. Since then, Hindu society has faced many more such assaults and succumbed to pious-sounding but devious reforms backed by poorly drafted draconian laws in the guise of combating real and imaginary social evils and enforcing farcical notions of gender equality. और ऐसे कई कानूनों को सुप्रीम कोर्ट तक ने कहा है, ये जो एनजीओज ने थोपे हैं, रेप लॉ, डाउरी लॉ, डोमेस्टिक वायलेंस लॉ, दैट लीगल टेररिज्म, और इसको बदलिए क्योंकि लाखों फैमिलीज हर साल तबाह हो रही हैं ऐसे उलझुल कानूनों से, बहुत ड्रकोनियन है और बहुत पोरली क्राफ्टेड है। और ये मैं आज नहीं कह रही हूँ, जब जब ये कानून एक एक आया तब मैंने क्रिटिक किया, तब इसके खिलाफ आवाज़ उठाई वगैरह वगैरह। But the Hindu society is unable to defend itself against attacks by its enemies because the elite sections among Hindus merrily join the sworn enemies of their faith and culture in endorsing draconian laws without paying attention to their actual intent and content. And I say it with confidence. MPs को भी पता नहीं होता वो क्या कानून पास कर रहे हैं. Now, coming to the politics behind the Muslim Women's Protection Act. By contrast, Muslim leaders have become more aggressive and determined in defending themselves from interference by outsiders in matters of faith and social practices, no matter how unfair and oppressive be those practices. Even during the British rule, they did not let the colonial rulers to tamper with matters related to their religion or family matters. They aggressively defend child marriage, arbitrary divorce, unequal inheritance rights for women, or oppressive practices such as polygamy, halala, triple talaq, or offensive dress codes such as burqa, niqab, hijab, in the name of safeguarding their religion. It is noteworthy that the Sharia Act of 1939, studiously enacted by the British, mind you, studiously avoided codifying Muslim personal law. It merely legitimized the existence of Muslim personal law without specifying its content. Thus, the issue was left to the discretion of political and Mazhabi leaders, but the British were never so timid in tampering with Hindu practices. Contrary to the popular stereotype, those who rise in defense of oppressive practices within Islam are not just medieval-minded, madarsa-educated mullahs and maulvis. When Rajiv Gandhi succumbed to the pressure of Islamists at the time of Shah Banu case, initially he had openly encouraged reformers like Arif Muhammad Khan to speak in favor of UCC in the parliament. Khan has openly alleged that it was not rabid mullahs but liberal Muslims of the Congress party such as Dr. Najma Haptullah, who persuaded Rajiv Gandhi to go against his own instinct and take a U-turn on the issue, which was Supreme Court ने शाह बानो के फेवर में जो एक pitiful सी judgment दी थी, उसको बनाए रखना है कि नहीं कि उसको overrule करना है. Leading the pack were people like Sayyid Shahabuddin, who had then recently retired from the prestigious Indian Foreign Service. तो ये पढ़े लिखे वेस्टर्न एजुकेटेड सारे लोग हैं. वजाहत हबीबुल्लाह, who was then an officer in the PMO, has revealed that another modernist liberal face of the Congress, namely MJ Akbar, played a key role in convincing Rajiv Gandhi that he should capture the Muslim vote bank by yielding to the demand of All India Muslim Personal Law Board against his own better judgment and nullify the Supreme Court verdict in the Shah Banu case by passing a new ordinance, which then later on resulted in the Muslim Women's Protection Act. Similarly, Professor Tahir Mahmood and Justice Ahmadi, otherwise wearing the progressive hat, became advisors of All India Muslim Personal Law Board. This ensured handsome rewards for both. Tahir Mahmood, who was appointed chairman of the Minorities Commission as a quid pro quo, while Justice Ahmadi became the Chief Justice of the Supreme Court in later years. Now, coming to the nitty-gritty of Shah Banu case, a lot of interesting things happened during that, and since I was a witness to it and participated in those debates, the Islamic fury following the SC judgment in the Shah Banu case put Muslim women on the back foot. Shah Banu herself gave a public statement saying she regretted going to the court because she never expected her case to lead to so much disharmony in society. The few among the educated Muslim women who supported Shah Banu also fell silent when cries of Islam in danger rent the air. This could also be due to the fact that the historic Shah Banu judgment provided pitiful relief to Shah Banu despite her having fought decades-long battle to seek maintenance from her husband. बहुत कम लोगों को पता होगा कि शाह बानो को कोई बहुत बड़ी रियासत नहीं मिली सुप्रीम कोर्ट से कोई बहुत बड़ा अवार्ड नहीं मिला, केवल और केवल 179 rupees, which is much less than the minimum wage for even a jhadu pocha person in those days, was granted by the Supreme Court as maintenance under the Criminal Procedure Code, section 125, because she sought relief as a destitute, not as a wife who deserved maintenance after long years of marriage. To start with, independent leftists, Communist Party leaders, as well as feminists of all hues had come out strongly in support of the Supreme Court judgment in favor of Shah Bano, and even lent their voice in support of a non-discriminatory uniform civil code. But when the Rajiv Gandhi government succumbed to Islamic pressure and enacted a new law to bypass or nullify the Supreme Court judgment, the BJP, the RSS, and other Hindu-minded organizations jumped in the fray and attacked Rajiv Gandhi full blast. This alarmed the leftists no end because they quickly sensed that BJP's ability to consolidate Hindu outrage on this issue would go against the left and lend further electoral strength to the BJP. Therefore, within no time, the entire spectrum of leftist and feminist opinion began to trash the demand for UCC as a right-wing conspiracy against the hapless Muslim minority. They did not just stop at junking the UCC, but went further and began to trash all demands for reform in Muslim personal law as constituting an attack on a vulnerable religious minority and an assault on religious freedom. With this U-turn, BJP became the prime target of attack by leftists and secularists, while brazenly oppressive and inhuman practices of the Muslim community came to be defended in the name of religious freedom and minority rights. That trend has been consolidated much further ever since the BJP came to power at the center. First time in 1996 with Atal Bihari Vajpayee as the Prime Minister, and then, of course, after Modi became Prime Minister in 2014, and the fact that the BJP manifesto openly commits itself to enacting a uniform civil code, the hostility of the left and left-aligned feminist groups to the idea of UCC has assumed pathological dimensions. Today, the move to introduce a uniform civil code is being dubbed as an authoritarian demand by Hindutvavadi fascists out to decimate religious minorities. और कोई बड़ी बात नहीं है, अभी यूनाइटेड नेशंस में तो इस्लामोफोबिया पे रेजोल्यूशन पास हो गया ना मार्च 15 को, तो ये लेके भी मोदी सरकार को यूनियन में भी घसीट लिया जाए कि देखो रिलीजियस फ्रीडम के साथ टैम्पर कर रहे हैं और यूसीसी के पीछे पड़े हुए हैं. This unmerited demonization campaign, and actually it's so ill-advised. I don't understand. ये आ बैल मुझे मार वाली राजनीति मोदी जी क्यों खेल रहे हैं? क्यों इतनी इनको चिंता है मुस्लिम महिलाओं की, जो अपनी चिंता खुद करने की सक्षमता रखती हैं, पर मोदी जी को लगता है that he is the knight in shining armor, उनको रेस्क्यू करना है. I wish he went slower on these issues. This unmerited demonization campaign with global ramifications has put the Modi government on the back foot. Therefore, it is bending itself backward to placate and win over Muslim leaders with a plethora of special schemes. 30% housing तुम्हें दे रहे हैं, jobs में बढ़ोतरी, करोड़ों रुपया स्कॉलरशिप्स लुटा रहे हैं, आई और सिविल सर्विसेज में स्पेशल एंट्री के तरीके निकाले जा रहे हैं. क्या क्या नहीं किया जा रहा. मौलवियों को, मदरसों को पैसा दिया जा रहा है. वो तृप्तिकरण करते नहीं थक रहे मोदी जी, पर तृप्ति हो नहीं सकती क्योंकि तृप्ति तो एक ही चीज़ से होगी, वो है Mission Ghazwa Hind. Anyway, in the process, the core support base of the BJP among Hindus is outraged at Modi government's hapless capitulation before the tyrannical might of Islamists. However, in the meantime, there's a growing ferment among Muslim women who are deeply disappointed at the fact that their political and Mazhabi leaders are not one bit serious about honoring the promises they made in the form of Muslim Women's Protection Act of 1986. To begin with, the All India Muslim Personal Law Board had made a public commitment that they would codify the mandates of the Muslim personal law. It's been nearly 4 decades since that promise, but the codified Muslim law is nowhere in sight. ये आपको हैरानी होती है इस बात से कि मुस्लिम पर्सनल लॉ का इतना शोर मचाते हैं, पर मुस्लिम पर्सनल लॉ है क्या? कोई वेबसाइट बता दिया आपको? कोडिफाइड आज भी नहीं है. ब्रिटिश ने नहीं किया, उसके बाद पोस्ट इंडिपेंडेंस इंडिया में किसी मुस्लिम संस्था ने नहीं किया, और ऑल इंडिया मुस्लिम पर्सनल लॉ बोर्ड इसीलिए बना था कि हम बताएंगे क्या है हमारा लॉ, पर आज तक नहीं किया, और फिर भी इतना सेक्रेड है. दिस इज enraged the informed sections of Muslim women because the absence of codification keeps them hostage to the whimsical actions of Muslim men backed by fatwas of corrupt elements within the clergy. Many of these fatwas are not even in compliance with Quranic injunctions or claimed provisions of Sharia, which again remains uncodified. Sharia भी uncodified है, Muslim personal law भी uncodified है. परंतु जुडिशल इंटरवेंशंस बहुत सी हो गई. The nemesis of Islamists has come from the fact that they do not even have the competence or capability to ensure that the meager rights promised under the Muslim Women's Protection Act of 1986, a law they coerced Raji. अच्छा ऐसा है, इसमें मैंने अगले कुछ पेजेस हैं जिसमें मैंने डिस्क्राइब किया है कि जुडिशल इंटरवेंशंस कौन कौन सी हुई हैं, कौन कौन मुस्लिम महिलाएं गई कोर्ट में, फिर सुप्रीम कोर्ट तक पहुंची शाहबानो के बाद, और वो सारी हिस्ट्री मैंने ब्रीफली ट्रैक की है. ये तो पेपर तो इससे बहुत बड़ा है, और कैसे एक के बाद एक जजमेंट आई हैं, बहुत ज़्यादा नहीं पर फिर भी बहुत हिस्टोरिक जजमेंट्स आई हैं, जिन्होंने ये जो सारी प्रोविजंस हैं, ट्रिपल तलाक और उसके साथ जुड़ी हलाला प्रथा जो है, और कई सारी जो इंस्टेंट ट्रिपल तलाक स्पेशली, और उसके साथ जुड़ जाती है हलाला और पॉलीगमी, इनको सुप्रीम कोर्ट ने बहुत स्पष्ट शब्दों में कई इम्पोर्टेंट पाथ ब्रेकिंग जजमेंट्स के माध्यम से इलीगल अनकॉन्स्टिट्यूशनल करार कर दिया. तो जो शाहबानो के समय सुप्रीम कोर्ट को इन्होंने धूल चटाई थी और उसके जजमेंट को ट्रैश करवा दिया था बाय थ्रू एजिटेशंस एंड पॉलिटिकल लॉबिंग ऑफ वेरी विरुलेंट काइंड, वो अब वो न्यूट्रलाइज हो गया. अब सुप्रीम कोर्ट थोड़ा संभल के और इन्हीं के शरिया को कोट करके, कुरान को कोट करके काफ़ी इम्पोर्टेंट जजमेंट्स दिए हैं, जिसके लिए मेरे पास टाइम अभी बताया गया नहीं है. तो फिर कभी या जब पब्लिश होगा तो आप पढ़ लेना. खैर, तो सबसे पहली बात, टू सम अप, मुस्लिम वुमेन हैव बीन 5 नहीं 10 मिनट लूँगी. अरे आपने अभी नोटिस दे दिया मुझे.
No problem.
और
This is just to remind you.
ओके, हाँ,
7-8 भी
अच्छा ठीक
10
है,
भी लग जाए कोई बात.
ओके. और इनमें सबसे ज़्यादा, देन नाउ दैट आई बीन गिवन ए लिटिल लीवे, सबसे ज़्यादा इम्पोर्टेंट रहा है शायरा बानो का केस 2016 में. She filed a petition when after 15 years of a very abusive marriage, her husband unilaterally divorced her. Talak, 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 out. Now, the important thing is, unlike Shahbano, and this is very important to understand, the changing political clout of Muslim women, which is something we should celebrate. Shahbano had gone to Supreme Court only and only because the meher promised to her had not been given to her. The pitiful meher or whatever was supposed to have been given to her, या तलाक इद्दत में जो देते हैं वो भी नहीं दिया था. She went to seek relief only on that, citing that she is indigent, she is destitute, and the Supreme Court, as I said, gave her a princely sum of ₹179. और उस पे भी इतना बवाल हो गया. But by the time we come to Shaira Banu, and even in between, Shaira Banu has openly, frontally challenged all these practices, which is triple instant talaq, halala, polygamy, and the entire range of things. And has she approached the court saying these are illegal, they are unconstitutional, they violate the promise of equality as far as Muslim women are concerned. So this is no more seeking personal relief, that I should have been given some maintenance, that I should get child support. None of that. She frontally challenged the Muslim personal law. And the 5-member bench of the Supreme Court, though gave a split verdict on the issue, but the majority vote, which is 3 judges versus 2 minority vote by one Muslim judge and another Sikh judge. Now, interestingly, so the majority vote went in favor of Shaira Banu, and it gave her all the reliefs that she had demanded. But interestingly, अब देखिए कितना डरती है सरकार मुस्लिम पर्सनल लॉ को लेके. 5 मेंबर जज, उसमें एक क्रिश्चियन है, एक जू है, एक पारसी है, एक सिख है, मतलब एक हिंदू है. दे डोंट इवन डेयर कि जैसे रोस्टर चलता है चलने दो. ऐसा कभी नहीं होगा जब खाप पंचायत के ऊपर कोई कानून पास करना होता है या कोई और हिंदू लॉ को अटैक करना होता है, तो कभी नहीं कहते कि केवल वहाँ हिंदू होने चाहिए या बैलेंस होना चाहिए. और इस बहुत ही इम्पोर्टेंट हिस्टोरिक जजमेंट ने इन सब प्रैक्टिसेस को अनकॉन्स्टिट्यूशनल करार कर दिया और ये नहीं माना कि ये इसेंशियल प्रैक्टिसेस. The Muslim Personal Law Board said these are essential practices of Islam. And the Supreme Court judges cited Quranic injunctions and Sharia and other things, saying there's nothing essential about these practices, that Islam can survive even if these practices are done away with. And with a clear verdict from the Supreme Court on July 30, 2019, Muslim Women's Protection of Rights on Marriage Act was passed by the Parliament after a very long discussion and heated opposition. And starting August 1, 2019, triple talaq became illegal in India, and also it became a punishable offense. Also, Muslim women can now demand maintenance for their dependent children. Thus, slowly but surely, the very offensive aspects of Muslim personal law as per the women of the Muslim community have been knocked out, are getting knocked out slowly but steadily, but only benefiting those women who can actually go to court. जो कोर्ट नहीं जाने की हैसियत रखती तो उनको तो फिर अपने कम्युनिटी के ही मापदंड से चलना पड़ता है. However, even though these are very major achievements for Muslim women, but all these positive developments do not get the BJP any nearer its manifesto promise of bringing about a uniform civil code applicable to all citizens, irrespective of religion, caste, region, or gender. The resultant stalemate threatens to tear asunder our polity. और आपने देखा था CAA, Citizens Amendment Act, कुछ नहीं था उसमें. केवल और केवल ये था कि जो 35,000 परसिक्यूटेड हिंदूज पाकिस्तान या बांग्लादेश से ऑलरेडी आ चुके हैं हिंदुस्तान में, उनको सिटीजनशिप दे देंगे, साथ में पारसी को भी, साथ में क्रिश्चियंस को भी. मतलब इतनी भी हिम्मत नहीं थी मोदी सरकार में कहने की कि हिंदू ही परसिक्यूट हो रहे हैं, तो जहाँ भी हो रहे हैं परसिक्यूट, चाहे पाकिस्तान, अफगानिस्तान, बांग्लादेश में, तो वो अपने घर वापसी कर सकते हैं, हम सिटीजनशिप राइट्स देंगे. ऐसा नहीं कहा. केवल 35,000 जो परसिक्यूटेड ऑलरेडी यहाँ रेफ्यूजी थे बने हुए, उनके लिए था CAA. और आपने देखा कैसे सारे देश में आग लगाने की बात हो गई थी. शाहीन बाग एजिटेशन, फिर एक के बाद एक किस तरह बवाल हुआ और डर गई मोदी सरकार. तो आप सोचिए, यूनिफॉर्म सिविल कोड की अगर बात होगी तो, और फिर इलेक्शन ईयर है, तो जाहिर है कि इतनी हिम्मत तो जुटाने वाली नहीं है मोदी सरकार. So I have offered, way back in 1985 itself, at the time of Shah Banu controversy, I offered a very simple solution to break this stalemate. कि सांप भी मर जाए और लाठी भी ना टूटे. अब हो सकता है अगर हम इसको प्रेस्टीज इशू ना बनाएं। बीजेपी ये जो प्रेस्टीज इशू बना दिया है कि हम नेशनलिस्ट हैं और हम यूसीसी ला के दिखाएंगे, ये मूर्खता जो है ये बहुत महंगी पड़ रही है बीजेपी को। The only way to break the stalemate on UCC is to undo the damage done by the Nehru-led government by forcing India's secular courts to assume the responsibility of arbitrating family disputes on the basis of laws claiming religious sanction, be it Anglo-Saxon Hindu law or Anglo-Saxon Islamic law, as legitimized in the Sharia Act of 1937. ये शरिया एक्ट भी 37 का कोई नहीं कह सकता कि ये सही में कुरान से और हदीस से लिया था. It is therefore time to take the bull by the horns, and this is coming to the end part, and confront Islamic leaders with the question: if you are serious about the divine sanctity of Muslim personal law, why do you willingly submit to adjudication by India's secular courts, where Kafir judges unfamiliar with the intricacies of Islamic law and zero knowledge of Arabic are expected to decide matters based on deep knowledge of Sharia and Quran? It is akin to having IS officers manage the affairs of mosques and deliver Friday sermons or lead Eid prayers. तो आप अपने religious affairs को फिर खुद क्यों नहीं मैनेज करते हो? कोर्ट में क्यों जाते हो अगर ये डिवाइन लॉ है और आप उसको उसकी इज्जत बरकरार रखना चाहते हो? They also need to answer as to why they failed to codify Muslim personal law. If it is so sacred, its essential features should be codified and made available to the entire community, not in Arabic but in languages they understand. वैसे Arabic में भी नहीं इन्होंने कभी किया. While it is understandable that the government of the day may not be able to honor all its promises made in the directive principles of the Constitution, no government should be allowed to get away with enacting laws that are patently contrary to and violate the mandate of the Constitution, which is directive principle से UCC enact करना है. चलिए आप यूसीसी नहीं कर सकते तब यूसीसी का ऑपोजिट तो कम से कम मत कीजिए ना कि केवल हिंदुओं को पेल रहे हैं आप. My proposal for breaking the stalemate is a slightly revised version of my 1985 proposal, which I had published in Manushi Journal. It enables the government to restore the sanctity of the directive principles while freeing itself from the charge of tampering with religious freedom of Muslims. And yet, it opens the door for reform for those Muslims who are desirous of it without coercing the reluctant ones to accept it. Okay, the bare outline. The secular courts of our country should stop adjudicating disputes on the basis of personal laws of any community. Hindu Marriage Act, no. Secular Marriage Act ही चलेगा, आप secular court में आए हो. Christian Marriage Act, no. वो church में जाओ. या Muslim पर्सनल लॉ सेक्युलर कोर्ट में इसकी कोई जगह नहीं होनी चाहिए, क्योंकि हमारे सेक्युलर जजेस नहीं है ट्रेंड टू एडजुडिकेट ऑन दीज मजहबी मैटर्स और धार्मिक इश्यूज. Instead, the state should confine itself to adjudicating cases only under the already existing secular laws, such as the Indian Marriage Act, Indian Divorce Act, Indian Succession Act, and Indian Wards and Guardianship Act. ये already है. थोड़ा सुधार करने की ज़रूरत है वो कर लो, पर वो है आपके पास सेक्युलर लॉज, तो अब यूसीसी काहे को चिल्ला रहे हो? In fact, we do not need to enact a new uniform civil code. The already existing Indian law should be applicable to all citizens that decide to approach secular courts, irrespective of their caste, creed, gender or religion. Now the point is, जिसको पर्सनल लॉ चाहिए, those who wish to continue with the customary practices of their community, claiming religious sanctity or customary sanctity or attachment to their traditional system, should be free to do so, provided they speedily codify those provisions and don't expect secular courts of India to adjudicate and enforce religious laws. बस 2.5 मिनट दे दीजिए. Please, did you mind? मैं थोड़ा सा.
No, that's okay.
Okay. Those who want their religious laws should get their traditional customs enforced through consensually acceptable authority of their community, be it local imam, granthi, family priests, जाति पंचायत और the spiritual gurus of the concerned sect. और जैसा आज भी होता है, बहुत से झगड़े हमारे हिंदू समाज में भी, जहाँ वेल निट कम्युनिटीज़ हैं, वो समाज में ही सुलझाती हैं. हर बात पे कोर्ट कचहरी के चक्कर, कहते हैं ना कि शरीफ लोग नहीं जाते हैं, ये आज भी मान्यता है. तो वो मान्यता अच्छी मान्यता थी और वो तोड़नी नहीं चाहिए थी हमें. However, if even one party to a dispute feels dissatisfied with the verdict of the authority adjudicating customary law, she should have the right to approach the secular court set up by the state, where the dispute should be adjudicated only within the framework of the secular laws applicable to all citizens. तो जिसको खुशी नहीं मिल रही है अपने हिंदू कस्टमरी लॉ से या यादव कम्युनिटी में जो भी कानून कायदे हैं, जो भी वो खुश नहीं है, वो पहुंच जाएं कि हमें न्याय नहीं मिल रहा, तो एक तो केसेस बहुत कम हो जाएंगे. दूसरा, ये हमारे जजेस बहुत इलिटरेट हैं इन मामलों में, नहीं पता है इनको कि ग्राउंड रियलिटी क्या है, तो उनका भी भार हल्का हो जाएगा. एंड one of the plus points of not forcing uniformity is that there are several communities in India where women's rights have been better protected through their established customary practices than in the reformed Hindu laws. For instance, even today, there are matrilineal communities in India, though shrinking in number and influence, where property devolves in the female line और बेटियों को माँ का ही नाम दिया जाता है, family name, not paternal name. And property also doesn't go from father to son, but from mother to daughter. This will allow those communities which have good practices, much better than Hindu Succession Act, to protect their pro-women culture and inheritance patterns and family structure, and without any cost. कंगाल हो जाती हैं families courts में जाके, तो क्यों ना जहाँ हो सकता है उसको strengthen किया जाए. Now, lot of people think this amounts to giving a free hand to regressive elements among Hindus, Muslims, Christians, Sikhs, all. And therefore, ये क्या उनको खुली छूट दे दी? I think people need to understand that family laws enacted by the state, and this is very, very important, come into play only when someone invokes their protection through police and law courts. Those who settle their affairs internally, no matter what the Hindu marriage law says, no matter what the Hindu Succession Act says, उनको फर्क नहीं पड़ता है. कोर्ट तभी लोग जाते हैं जब अपने अंदरूनी मामले खुद नहीं सॉल्व कर पाते. तो अभी भी ज़्यादातर झगड़े कम्युनिटी ही सुलझाती है, और कोई बुरी बात भी नहीं है क्योंकि तुरंत हो जाते हैं. और वेल ऑर्गेनाइज्ड कम्युनिटीज़ मेक श्योर दैट घर की बात, बिरादरी की बात बिरादरी में रहे, और ये बहुत अच्छी प्रथा है मेरे हिसाब से. These laws, the best of laws, cannot be imposed on people who do not wish to avail of the rights under those laws. For example, beating up one's wife or preventing a daughter from continuing with her studies through physical violence are both punishable offenses. But if a battered wife or a daughter held captive by her father to prevent her from studying chooses not to seek redress in court or refuses the offered help, पुलिस उसको हेल्प भी करना चाहे, वो कहे नहीं मुझे नहीं चाहिए, the best of laws cannot be of any help to her. So what I am suggesting therefore is कि optional रखिए, जो secular laws हैं वो already हैं enshrined, उनको सुधारना है, थोड़ा बहुत सुधार लीजिए सबसे सलाह करके, जिसको वो ज़रूरत है वो पहुंच जाए. पर किसी भी कम्युनिटी के, ना हिंदू, ना मुस्लिम, ना सिख, पर्सनल कस्टमरी लॉज को कोर्ट में लाने की आवश्यकता नहीं होनी चाहिए. थैंक यू वेरी मच.
Thank you for that very comprehensive and insightful lecture on a difficult subject.